All right, I think we're going to get going. The guys will catch us on the way. First of all, thank you very much for coming through and registering for this webinar that is sponsored and brought to us by Jewel Weddings. So thank you very much to them for sponsoring it. It's going to take about 20 to 30 minutes for the presentation, whereafter we'll get into about 15 or so minutes of questions and answers. So I'm going to encourage you to write your questions as I go through the presentation. You can either put them in the chat box below, or alternatively, just record them, on a piece of paper, and then we will take questions at the end. I would also suggest that perhaps it will help you if you pan your phone or you put your phone on landscape so that you can be able to view the presentation a little bit easier. So without wasting much time, I'm going to get into it. Maybe just tell you a little bit about myself, just introduce myself for those who don't know me. I am Lwazi, that's my name. Dekeda is the surname. I am married with 2 children. In fact, I will be married for 14 years on Wednesday. Yep, Wednesday is my 14th year anniversary with my lovely high school sweetheart, Soso. So yeah, married, got 2 children, got an 11-year-old daughter and a 10-year-old son. And yeah, I'm loving being a parent. So I'm also a practicing attorney, notary and conveyancer. And I was admitted as an attorney in August 2003, and also became an notary and conveyancer in 2008. Basically, what a notary is, for the benefit of those who perhaps may not be familiar, a notary is an attorney who has a special qualification in undertaking different types of legal transactions, including antenuptial contracts, which we'll be touching on a little bit this evening, as well as registering rights in mineral rights and all sorts of other things as well. And a conveyancer is one who is specialized, or an attorney who has qualified in the transfer of immovable property. So that's what that is. So we are the co-founders, or I'm one of the co-founders of Jewel Weddings, having founded it with my wife in December of 2012. And Jewel Weddings is a wedding planning business. We are very passionate about weddings. We are passionate about marriage. And therefore, wherever there's marriage, wherever there's weddings, that's where you will find us. And I'm an ordained pastor. I'm also a marriage officer. I'm an author and speaker. And if you want to read a little bit more about what I do in the authoring and speaking space, you can go on to my website, which is on the screen there, which is lwazidekeda.co.za. All right, so what are the objectives of the presentation this evening? Basically, it is to create an understanding around the different ways, we call them regimes in law, but the different types or systems in terms of which individuals can get married. And we're also going to be identifying and looking a little bit of the impact of each different type of marital system. So we're going to deal with the traditional 3 marital systems as provided for by civil laws of the Republic of South Africa. And the very first one that we're going to be dealing with is a marriage in community of property. Now, I'm sure that most of you might or should be familiar with this type of marital regime. And the way that this one works is that before people are married, okay, let's say in the example given there on the presentation, we have Mr. on the side and we have Mrs. So each one of them have their own separate or individual estates. Basically, your estate is made up of your assets and your liabilities. So that's what comprises an estate. So Mr. over there would have a separate one, and Mrs. Now, when you get married in community of property, the law sees you as one person and you have what is called a joint estate. So in other words, you share in assets and liabilities. So in the eyes of the law, you're no longer seen as individuals, but then you're seen as one person, and thus the name, the joint estate. What are the consequences then of this marriage? Basically, you have an equal and undivided share in the estate, in the joint estate. So There is no saying that, you know, this belongs to this one and this belongs to the other person. You're basically considered to have an equal and undivided. Basically, undivided means that you cannot say, no, it's 50-50 or whatever it is, but it's an equal share and it's undivided. And one of the other consequences of this type of marital system is that if one of the parties, let's say you go out and you make a loan with Edgar's or whatever, you know, creditor, and you get into trouble, what the law says then, because you have a joint estate, because you're seen as one person, the creditor can go against each and every one of you. You know, he doesn't have to, you know, go against the person who opened up the account, because you automatically, you know, put the other person in liability. So the other person becomes liable for whatever debts that you may have had. And that's one of the challenges actually with a marriage in community of property, is that it creates that risk factor. So there is a risk that is attached then to that type of marital system. And then in relation to transactions, there are certain transactions that you cannot, you know, get involved in without the cooperation of the other spouse. So the other person always has to be in the picture. They always have to, you know, give consent and indeed sign consent. These, you know, type of transactions I'm talking about, maybe purchasing immovable property. So if you're purchasing a piece of land or you're purchasing a house, then it will need the other person to sign consent there too. And then also, if you are in business, so let's say you are in business, and you, as the members or the directors of that business, you then decide that you're going to take out a loan. So you're going to take out a loan with a bank to fund the operations of the business. Now, the person who is involved in that business, who's married in community of property, you may very well find, and it's quite commonplace, that the bank or the loaner would require that the members of the business sign surety. So they stand in the place of the entity, that in the case that the entity does not meet its obligations, they will then, you know, meet those obligations, or they are entitled to go against the individual members or the individual directors or shareholders in the entity. Now, if you're married in community of property, that then involves your wife as well, or your husband, who then has to also sign surety. So that becomes a challenge then, because you then obviously opened up, you know, your whole family to risk, and you open up your whole family, you know, to being subject to that debt. And then what happens at the end of the marriage, because there are two ways that a marriage ends. A marriage is either it ends on death or on divorce. So when you're married in community of property, what happens at the end of the marriage is that there is a division of the joint estate. So typically what would happen is that all the, you know, all the liabilities will be settled. So whatever income there is, whatever funding there is in the joint estate, will go towards settling whatever liabilities the parties jointly have. And if need be, it may also lead to a situation where there would have to be a liquidation, you know, a selling off of some of the assets. If the parties don't have hard cash on them to settle, you know, from the assets of the joint estate, then those would be sold to settle the debts. So that is a marriage in community of property. It is fast becoming unpopular these days because of its, you know, consequences, and because of the risks that are attached to that type of marital system. And it's very much not advisable, especially for people who are in high risk occupations, or who are planning or are currently involved in business. It's always best to choose another legal system. Okay, secondly, we have a marriage in out of community of property without the accrual system. So you remember from the first example, we had the two individuals before they were married, they maintained their two separate estates. Now, in a marriage out of community of property, with the application of the accrual system, similar vein, you have the two parties maintaining their separate estates, and they maintain these separate estates throughout the course of the marriage. So throughout the course of the marriage, they operate independent of one another as it relates to their commercial, transactions. So the consequences, as I said, they maintain their separate estates. So there is no sharing in assets. There is no sharing in liabilities. And yeah, just for the sake of those who have joined us, I see some are joining us as we go along. Don't worry, what you have missed, I will send a link where you can download the video to this presentation and you can refer to it later on. So you maintain your separate estates in this type of marital system. And as it relates to creditors, if a person makes a debt, they are liable for that debt in their own stead. So the sheriff can't go to your house and you are the party who did not make that debt and you have purchased certain items or certain assets. The sheriff can't go against those because you can simply just produce your antenuptial contract, which is the agreement that is entered into when you enter into a marriage out of community of property. So you produce that to the sheriff and you say, look, we're married out of community of property. I own these assets, I bought them, and they have nothing to do with the other spouse. Now, because of that maintenance of that separate estates, then you're protected in that regard. Now, different to a marriage out of community of property rather, in a marriage out of community of property, there is no need for one spouse to get the consent of the other spouse if they're entering into transactions like purchasing immovable property, like signing surety for a business that they may be involved in. So in that regard, it's a complete separation economically and in terms of how they transact their business. Similar vein, I mentioned the business story there. So once again, a marriage comes to an end on death and on divorce or on divorce. So what happens in this regard, if you're married out of community of property without the accrual system, then you basically just take whatever was in your estate at the time or wherever is in your estate. As I mentioned earlier on, you maintain those separate estates. So at the end of the marriage, there's no sharing in anything. You take basically what is registered in your name and you go your separate ways. Don't worry if I'm going a little bit too fast. If you need clarity, we will be entertaining questions a little bit later on. So you can make a note of the stuff that you need clarification on, and I will gladly explain it to you. I just want to make sure that we get the presentation out of the way in the time that we have, and then we can get into a time of engagement a little bit later on. So now we're going to talk about a marriage out of community of property with the application of what is called the accrual system. Now, I think where we need to start here is maybe with an explanation of what the accrual system is before we get into the nitty-gritties of that one. Let me just get to that slide. Okay, now this slide is titled Understanding Accrual. So basically what accrual is, and I think as the name suggests, accrual is the growth. It is the growth in the estate of an individual. So basically from the time when you got married to the time when the marriage comes to an end, because accrual comes into play, and you're going to see it now in the example, but accrual comes into play only at the end of the marriage. So what happens then with the accrual is that, let's say for argument's sake, at the time the parties got married, Mr. had an estate, a net estate. When I say net estate, what I mean is that it is assets minus liabilities. So they had a net estate of 500,000, and let's say Mrs. had a net estate of 600,000 in terms of value. So now comes the end of the marriage, and then we calculate, okay, now how much has the estate of Mr. accrued or grown by? What is its current value? And we say in this example, the current value is 900,000. And we say for Mrs. it is 800,000. So basically now we have to calculate the accrual. For Mr., the accrual or the growth in the estate would be 400,000. It's the 900 minus the 500. And then for Mrs., the accrual or the growth will be the 200,000. All right. And then what the law then says, before I get there, what the law then says is that, okay, now the formula that we're going to apply now to make a division of the accrual is to say the person whose estate has accrued the least is entitled to half of the difference between the two respective accruals. Okay, I'm going to repeat that. The person whose estate has accrued the least, okay, so in this scenario, we have Mrs. whose estate has accrued the least because she's 200 and Mr. is 400. So the law then says that they're entitled to half of the difference. So what is the difference between the two accruals? 400 minus the 200, the difference is 200,000. So then the law says the person whose estate has accrued the least is entitled to half of the difference. So half of the difference then takes us to 100,000. And then the law says that there must be a transfer. So in other words, Mr. has accrued the most, so he must transfer 100,000 to Mrs., who then gets 100,000. All right, so then you basically see that they both end up with 300,000. Now, it's not always the case, and I'm going to get into that in the next slide or in the slide before. We just jumped some slides because I wanted for you to understand how the accrual works. So if we go back to our initial slide, when we deal with the consequences of a marriage out of community of property with the accrual being applicable. So basically, during the course of the marriage, a marriage out of community of property with accrual is the same as a marriage out of community of property without the accrual, or a marriage out of community of property straight, as it is also termed. So during the course of the marriage, it is the same. So the accrual only comes in at the end of the marriage. It only comes in when we have to then make a calculation. And so when I mean then by saying that it remains the same is that, I mean, you're free to then deal with your assets as you deem fit. You are protected in terms of the debts of the other person. You know, you don't have to get them involved in certain transactions like purchasing immovable property, like signing sureties for a debt that the business may be taking out. So in that regard, there is that individual participation, you know, economically. All right. So we've explained what the accrual is, and I hope it is clear, but we'll see from the questions later on. And welcome those who are joining us. Just to also mention again that even if you're joining us late, don't worry. We will be emailing you a link to download the entire presentation so that you can catch up where you missed out. So in the accrual, you remember now we talked about the net value of the different estates of the different parties when they got married. So those are what are called commencement values. Okay, so commencement values are those figures right there, the 500,000 and the 600,000. Now, one does not have to stipulate commencement values. In other words, you can say, and this is quite common for young couples, when you're getting into a marriage to say, look, whatever I have now, you know, let's get into it, you know, together. It's fine. Let's put it into the mix of the accrual and let it be taken into account when we are calculating the accrual. Because the other side of the coin, as we have in this picture, is to say, no, we want to stipulate commencement values. So basically the parties in the antenuptial contract would state what the net value of their estate is, you know, at the time of entering into their marriage. And there may be different reasons. People have their personal reasons why they would want to stipulate commencement values. Some might say that, look, you know, you are not in the picture when I started working, and for whatever reason, I don't, you know, feel right that you share in the accrual or in what I had at the time that we got married. You know, it's a personal choice, really. So one can then stipulate those commencement values. And what then happens is that when we calculate the accrual, which is that figure there. Remember, we said Mr. had grown by 900, resulting in an accrual of 400, Mrs. by 800, resulting in an accrual of 200. So basically, when we calculate the accrual, because obviously the value of money changes over time, we basically have to update that figure or those commencement values to what their current value would be in 5 years' time, in 10 years' time. So we do that by applying inflation. Apply inflation. There are tables that actuaries put out, and then we bring those figures to what they are in modern day terms. So we do that as a first step, and then we calculate from that basis how much the estate of the respective party has grown by. So that's the whole story about accrual. Those are the commencement values. Now, ratios. Remember, I said when I was explaining to you the formula that we use when we divide the accrual, where we say that the party whose estate has accrued the least is entitled to half of the difference. So basically a 50-50 split. But it doesn't have to be like that. Parties can, in their antenuptial contract, or their ANC, as it is commonly known, they can stipulate that the person whose estate has accrued the least is entitled to 80%, entitled to 70% or 60%, whatever percentage that you agree upon. So the ratios can be different there. All right. Also, what we can do in respect of the accrual is to say that, look, in the event that either of the parties are insolvent at the time of the calculation of the accrual, then accrual will not apply. And the reason why you'd want to do that you want to exclude accrual if either of the parties are insolvent. Now, what insolvency is basically when you have been declared by the court that you are unable to pay your debts, when your assets are exceeded by your liabilities. Basically, you're in a negative position or a negative situation. So to explain this further, to go back to our example again of the respective accruals, if for argument's sake we were to say that Mr., okay, that's the commencement value, but if we're to say that Mr. now, the 900,000 is a minus, okay? So they are minus 900,000 at the time of the end of the marriage, at the time when we have to calculate the accrual. So basically they are in an insolvent state where their assets are exceeded by their liabilities. So if it were to happen then that there needs to be a transfer, what that would mean is that whatever is transferred from the person whose estate has accrued the most, the least rather, yes, the most, sorry, then it will go into that person's deep black hole, in other words, because they are now in negative. Their estate has been handed over to an administrator by the court, and their funds are then administered by that administrator who pays their debts, on a continuous basis until a period when their liabilities or debts, have been settled. Now, this person is then called an insolvent, okay? And they are sequestrated. Another term is sequestration, or you have been sequestrated by the court. And you can only reapply, to be rehabilitated or to be put back to a pre-sequestration position after a period of about 10 years. All right. So in the event then of there being insolvency, we can say in the antenuptial contract that accrual will not be applicable. One of the reasons why you'd also want to do that, let's say you've got children with your former spouse, and you want there to be money to take care for their needs and their maintenance. So now if that money is going to go towards this other spouse's debts, that will defeat that purpose. All right. Now we can also say, we can exclude, the accrual from having application as far as a membership share in a partnership or a dividend or a share in a company of the respective spouses or one of the spouses is concerned. So let's say, for argument's sake, I own 50 shares in ABC company, all right? And my marriage comes to an end, and then there has to be a calculation of the accrual. Of course, the value then of what I own in this entity, okay, is an asset in my estate. So now a situation may arise that, let's say I don't have cash enough to pay out the accrual to the other spouse, but I have these shares or I have this member's interest, which has a value. Now it may happen that I have to then liquidate or sell off these shares so that I can meet my obligations in terms of the accrual split. Now this can be problematic because it could happen that the company itself does not have liquid cash, as I said. So it has to then sell assets that it needs to operate. So we could then very well find a situation where this individual is unable to continue with life because it could be that this entity, this business, is their sole income generating activity. So then we would then say in the antenuptial contract, if your marriage out of community of property with the accrual system, we say accrual doesn't apply as far as though that value in those shares or in those members' interests is concerned, okay? But then this does not include any, you know, any money or any, let's say, dividend or share that has been distributed to us and is cash sitting in the bank. So that cash sitting in the bank forms part of the accrual calculation. All right. So that, in a nutshell, ladies and gentlemen, we've taken about 25 minutes. That, in a nutshell, is the three different types of, marital systems. Yes, the three different types of marital systems. So we are going to get into a time of questions and answers, just for there to be clarifications if you need a question to be asked, or you need some clarification. So I'm going to stop here my presentation, but I'm going to ask if we can be as brief as possible. Ask your question, but be as brief and to the point as possible so that we can get in as much questions or as many questions in the time that we have left. We have about 10 or so minutes left, so we can get as much questions in that as possible. All right, we may very well extend the time. If I see that there are a lot of questions, we may extend the time beyond that 10 minutes. All right, let me stop the presentation. I see that there are, you can ask questions in two ways, okay? You can either put them in the chat box, or you can unmute yourself or raise a hand, and then we can then take your questions. I'm sure I'm not that good at explaining that there wouldn't be any questions. Please feel free to ask your question. There is no question that is a silly question. Just feel free. We're all here to learn from one another. So you can either put it in the chat box, or you can just unmute yourself and let's have a discussion. Are we all clear? Are we all covered? Kate, do you have a question, or are you covered?
No, I'm not covered. Is it possible if I married into another marriage certificate, like out of community of property, then later on change into out of marital property with accrual without getting a divorce now?
Awesome. Thank you, Kate. Good question. Now, there's only one instance, and actually I thought I would deal with this. Thank you for bringing that up. There's only one instance when the law allows one to change their marital regime or to change the way that they're married. That is in terms of the Deeds Registries Act. One can apply to the court, I think it's section 97, if I'm not mistaken. One can apply to court to change a marital system from in community to out of community, either with the application of the accrual or without the application of the accrual. The unfortunate part is that once you're married out of community of property, there is no provision in law for one to change the marital system. Neither can you change from the application of accrual or add or take away the accrual. So once you have made your decision in law, save that as you intimated that you divorce and then you marry again, but then that also includes a measure of fraud, because when you divorce, you have to indicate to the court that, and give evidence to that regard, that you, the marriage has come to an end, you've fallen out of love with one another. So if that's not the case and you do that, then you would be committing a criminal offense. So that's the only instance, from in community of property to out of community of property, either with accrual or without accrual. Now, there are financial implications for that. Generally, one has, you can pay approximately about 4,000 to enter into an antenuptial contract, that is into a marriage out of community of property. And you do that before you go before the marriage officer and say, I do. So you have to sign that document. It doesn't have to be registered. It must be registered 3 months after that process. So that's how then you do it. So yes, to answer your question, Kate, you can't change. Once you've chosen marriage out of community of property, you're stuck in that marital regime.